Penelope East Town, Sanford Road. I very much believe in freedom of speech. I just don't appreciate it when people shove it in my face, their opinion, which may or may not differ from mine. And I'm afraid that once any regulations are removed, it's going to be very difficult to put them back in place if we decide we don't like what we just did.
Thank you very much for your comment. Martin, there's no mention of Tom Harris in the August meeting, so what we just did in July is the last record.
The lady on next.
I'm Attorney Deborah Stevenson. I'm here speaking on behalf of Elaine, who lives on Orchard Road. Seems to me that what is being discussed here obviously is political speech. First thing I want to address is the fact that if this is about primarily started with a sign having to do with Mr. Overton, as he did on earlier occasions when it involved something of personal interest, he recused himself. And I think that is the appropriate action to take, both in the other matters and in this matter. And I'm confused as to why on all these meetings, Mr. Overton has not recused himself on this issue. And I would ask that that occur, because that's the appropriate thing to do with regard to this issue whenever it comes up, public hearing or a vote or discussion. So that's issue number one. Issue number two is people are offended by the content of that sign and perhaps other political signs in town. Well, political speech is the foundation of what our First Amendment right to speak freely is all about. And we do not restrict people, even though the speech is offensive. There's only very few restrictions on the federal level under the United States Constitution that are restricted. For example, fire in a movie theater or a crowded theater. But otherwise, the content of your speech is not restricted. That is a primary reason why we have free speech. My speech can offend you, your speech can offend me. It's all protected. We have the right to do that. We have the right to offend each other, whether or not we like what's said. So that is the purpose of freedom of speech. That is why it's protected, particularly in the political arena. Now, as far as Mr. Overton is concerned, I don't need to keep singling you out, but the sign has to do, one sign in particular has to do with you. And whether or not you're paid is irrelevant. You are acting in an official capacity. And that rises to the level whether someone says you're wonderful or someone says you're not wonderful. The fact of the matter is that it's a political issue. You are a political figure. You are acting on behalf of the town government. So that's fair political speech, whether or not one likes the content. As far as the regulating of any political speech, I would ask you to address the Connecticut Constitution. Because if you have not read that, I urge you to do so, because it is even stronger language. That is, our speech is protected under the Connecticut Constitution, and that would be Article 1st, Section 5. Very short, very simple, very understandable, very clear. No law shall ever be passed to curtail or restrain the liberty of speech or of the press. I don't think it could be any clearer than that. So, this
Could I just ask you a question?
Yes.
Do you mind?
Henry?
Is the issue of shouting fire in a crowded theater subject to that constitutional requirement?
Yes, it is, and that's, but no.
Well, yes or
and
no?
The reason I say that is it says no, because it is not under the Connecticut Constitution that has been restricted. That's under the United States Constitution, and that has been interpreted by the United States Supreme Court to allow that. Now, I would argue that is a floor, but all the states, under their state constitution, can have higher restrictions, and that's what Connecticut does. So that's why it's yes and no. Under the federal, you can restrict that. Under the state, apparently, by the plain language, you could not. Okay? So what I'm saying to you is we live here in Connecticut, and we have to abide by the Constitution, federal and state. That's the way the law is. Those are the rules. And you have the authority to adopt all sorts of regulations, but every regulation that you adopt must conform and be in compliance with either or both, the United States Constitution and the Connecticut Constitution. So the question is, can it be regulated federally? Yes, but fire and crowded theaters, you would have leeway under the federal Constitution, under the Connecticut. It wouldn't be apparent that you
Thank you
don't.
for clarifying.
I have a question since you got that one. Ms. Stevenson, we've been given a lot of, can I ask the audience to stop talking? I'm having trouble hearing. Thank you. Martin, can you address the audience, please? This is the third time.
I think they're being very good.
I can hear them very clearly. There we go again. Ms. Stevenson, we've been given information on from our attorney and using the word substantial state interest. This has been reflected in legal opinions and in case law. Can you give us an example outside of what Martin was talking about with yelling fire in the theater? Other examples that would qualify that? Because that's a case law term, and I know you're an attorney.
Well, again, I'm not sure which one you're addressing in that letter. If you're addressing on the federal level, that there is a...
I would consider Connecticut only, given the context
Well,
of what
under
you just said.
Connecticut only, there has not, to my knowledge, there has not been any interpretation similar to the United States Constitution. It's all been related to the United States Constitution. Until
So
very
I want to
recently.
clarify the question here, because there was a whole lot of people here waiting to speak, and this commission wanted to hear you out, and they want to hear Sean's question and your response. But what I just heard you say is that there is no case law that defines an interpretation of the Constitution. Is that what you just said?
No, I said what he is addressing. Again, you have to look at Connecticut case law. When the courts are interpreting the meaning of the Constitution, the final word on the Connecticut Constitution is the Connecticut Supreme Court. Okay? Period.
And did you say then that the Connecticut Supreme Court has not ruled on a case?
No, I didn't say they haven't ruled on any case. What I'm saying is the fire in the movie theater comment, okay, the restriction on that, the leeway there, has been defined and repeated in many cases on the federal interpretation of the federal Constitution. But I have not seen that exactly, other than repeating the case law about the federal Constitution in reference.
That didn't actually ask, he asked for an example, another example.
I don't have
We have
one.
something that would be protected.
I
You
don't
have
have
one?
another example from the Connecticut.
Can I call?
Yeah, can I
One
ask you a
question.
question, because I'm just reading through a memo from our legal counsel here, and he clearly states that government may regulate time, place, and manner.
That's under the federal Constitution.
Okay. Can you speak to that? I mean, if we can get our message across, is there a difference between a 12-foot political sign and a 50-foot one, as long as we're giving someone freedom of speech?
Under the federal Constitution, there is leeway. Under the Connecticut Constitution, there has not been that same determination made, because we have a different wording in our Constitution.
But I'm circling around two questions here. If the courts have not ruled on this,
Then this applies. The plain language of this applies.
but the interpretation of that document becomes law, as
It is
every
law.
decision, every arbitration of the US Supreme Court becomes law, and it gets bigger and bigger and bigger as it covers more and more ground. And what I'm hearing is this ground hasn't even been broken yet.
That's pretty much accurate, okay? Under the Connecticut Constitution, because it's very clear, and that has not, but everybody is adjudicated under the federal Constitution.
Thank you very much. The lady in orange, I think, was next.
Martin, you never